now please distinguish. This argument would come from the other side, that you disqualified a prime minister under the constitution, and the right of appeal. Either the Supreme Court should have said, end of story, no right of appeal. Done, we've done it. They use the right of appeal that impliedly upheld the law. So how is this any different from what has been done here to the extent of grant of an appellate power under 184(3)? That's the simple question.
Well, because compare the language, my lord, of 204 with 184(3). Let's read 184(3).
Naturally, they're not identical. They can't be identical. They deal with different scenarios. But the concept of creating an appellate body, that is fundamental.
My lord, the concept has to be subservient to the express language of the constitution.
कहाँ लिखा है 204(3) में कि अपील लाई करेगी?
My lord, 184(3) में कहाँ लिखा है कि वो subject to law?
यार अब आप देखें, आप बहस हमसे ना करें, हम आपसे नहीं सर, 204 देखें ऐसे, this is not proper. No, hang on. 204(3) में अपील का पावर बता दें कहाँ लिखा है?
My submission, and your lordship obviously can
समझिए. देखिए आप गलत समझ रहे हैं, हम समझने की कोशिश कर रहे हैं.
My submission is that the power to regulate the exercise of the power of contempt will include the power to frame a law which allows for trial and creation of an appellate forum. That's my submission.
And this is what exactly has been done in the Practice and Procedure Act as well.
My lord, it is not, with respect, because the power conferred by 184(3), there is nothing in 184(3) which says that that power can be regulated, the exercise of that power can be regulated by law.
Surely you are not equating regulation with substantive right, creation of an appeal. If you are saying yes, they're interchangeable, that's a different argument.
The power to regulate the exercise of a constitutional power has been interpreted.
Okay, I'll note it. You're saying that power to regulate includes power to grant substantive right of appeal.
Power to yes, that's my submission.
That's
why I say
by law. You see, 243 says exercise of powers under this article can be regulated by law. When the law regulates it, then
it can provide an appeal.
It can provide an appeal.
Yes, that's my submission. And 184.
ये अब मेरे ख्याल में हमें आपके चीजें सुनना चाहिए. हम एक दूसरे को अगर हम कम से कम with the greatest respect अपने जजमेंट्स हम लिख लेंगे, मगर आप अगर हमें देखिए हमें आपका मौका नहीं मिल रहा है. आपस में तो हमारी बहस फिर शायद बाद में भी चलती रहेगी आपस में कि क्या बेहतर है क्या, बिकॉज एक नतीजे पे हमें पहुंचना है. ठीक है ना? तो देखिए हम जब सवाल पूछते हैं ना, उसका हम आपको मौका दें, क्योंकि अब हम आपको फोन करके चैम्बर में तो बुलाएंगे नहीं कि एक मेरे जहन में एक सवाल रह गया था वो भी आप बता दो. तो यहाँ आप हमें बता दें जो चीजें जो आपको, अगर आप देखिए अगर कोई दुश्वारी आ रही है तो आप कह दीजिए मुझे, मैं लिख के भी दे सकता हूँ, ये भी आपको
मैंने लिख के दे दिया. मैं फिर से बिल्कुल I bow to that. Exactly.
This point that you're taking with regard to 2043. In clause 3 of 204, the word used is law. On your theory, that has to relate to something in the federal legislative list. And you say that relates to NT 55.
No, my lord. It can, but I also said that there a specific provision in the body of the constitution can be a standalone independent power also. But here, since we are talking about the Supreme Court,
just stop. Then why cannot the power conferred, whatever its extent, under Article 191, why should that have to be related to something in the federal legislative list? Why should that not also be a standalone power in relation to the subject matter of the practice and procedure of this court?
Because
आपकी जो मुझे समझ आई ये बात, आप तो कह रहे हैं जी वो दो तरीके हो सकते हैं, और इस तरीके में 191 में जो law है that has to relate to something on the federal legislative list,
yes,
which is entry 55 according to you.
Yes.
लेकिन 204 में आप कह रहे हैं कि law as used over there is standalone, it doesn't need to relate to anything.
I'm saying it is connected. I'm saying that
Which one then? It is then 2043 का जो है law जो वहाँ पे जो इस्तेमाल किया गया है, which entry does it relate to?
Well, entry 55.
If it relates to entry 55, that says expressly authorized to enlarge the jurisdiction.
Expressly authorized by or under the constitution.
इसमें तो नहीं है कोई.
Well, I would say this would fit in probably in the under the constitution category. In the in 185.
But it has to be express. It's not express.
That is why, my lord, express under the Constitution.
No, but even under the Constitution, for example, if you look at the interim Constitution, if you look at the 62 Constitution, they had specific articles.
Yes, my lord.
To this effect, the Supreme Court shall have such other jurisdiction as may be conferred by law.
Article 188.
Whatever it is.
Yeah.
So that could be under the Constitution.
Yes,
right?
my lord.
As opposed to the examples that you gave, which were by the Constitution, express. But here, both are express. But here, there is nothing, and I'm talking of 2043, there is nothing express.
My lord, I bow to that. That is a difficulty with entry 55. And your lordship is absolutely right. Entry 55 is the same as entry 55 of the 1972 Constitution. But in the 1972 Constitution, entry 55 in its present incarnation had to be read with Article 188. And there
Could be read.
Could be read. And there you could draw the connection. But what the 1973 Constitution has done, it has omitted Article 188.
Actually, if you look at it, both the 73 and the interim Constitution, the relevant entry 55, they are very similar to, if not identical to, the equivalent entry in the Government of India Act.
Yes.
In relation to the federal court. In relation to the federal court,
Yes.
the 7th schedule, first list 1, that had a virtually equivalent provision. So these two articles
Well, with one difference. The entry in the Government of India Act only talked about enlargement by the Constitution. It did not use the word under the Constitution.
because there was nothing in there.
Exactly. So
Here we have the the interim Constitution, which did have that article, and the 73 did not. But by or under is there.
by and under is there. Now, your lordships have to give some meaning to the words under the Constitution.
So that's the question. You see, just so summing it up, what you said so far is that under 191